ProPublica has done an amazing job at humanizing the reasons why women need reproductive rights. This is a long article, so I'm just going to jump right into it. The article headline says, Texas lawmakers push for new exceptions to state's strict termination ban after the deaths of two women. The new legislation, prompted by ProPublica's reporting, comes after 111 Texas doctors signed a public letter urging that the ban be changed because it does not allow us as medical professionals to do our jobs. Here are the article's authors. Okay, like I said, this is a long article. It says, weeks after ProPublica reported on the deaths of two pregnant women whose miscarriages went untreated in Texas, state lawmakers have filed bills that would create new exceptions to the state's strict termination laws, broadening doctors' ability to intervene when their patients face health risk. The legislation comes after the lawmaker who wrote one of Texas's recent bans wrote an op-ed in the Houston Chronicle defending the current exceptions as plenty clear. But more than 100 Texas OBGYNs disagree with his position. In a public letter written in response to ProPublica's reporting, they urged changes. As OBGYNs in Texas, we know firsthand how much these laws restrict our ability to provide our patients with quality evidence-based care, they said. Texas's termination ban threatens up to 99 years in prison, $100,000 in fines, and loss of medical license for doctors who provide terminations of pregnancy. The state's health and safety code currently includes exceptions if a pregnant woman has a life-threatening physical condition aggravated by, caused by, or arising from a pregnancy that places the female at risk of death or poses a serious risk of substantial impairment of a major bodily function unless the termination is performed or induced. A separate exception exists that provides doctors with some legal protections if they perform a termination for an ectopic pregnancy or in cases when a patient's water breaks. The bills filed in the State House and Senate last week create new health exceptions. They would allow doctors to induce or perform terminations necessary to preserve the mental or physical health of a patient, including preserving the patient's fertility. Doctors could also provide terminations in the cases where the fetus has an anomaly, that would make it unable to survive outside the womb or able to survive only with extraordinary medical intervention. State Representative Donna Howard, who filed the bill in the Texas House, said ProPublica's recent reporting adds to evidence that the current legislation is a threat to the safety of pregnant women in Texas and increases the urgency to make changes. This is my reaction, she said. It's one of extreme sadness and disbelief that we are at a point where we're allowing women to die because we haven't been able to clarify the law. Investigations by ProPublica have found that at least 4 women, including 2 in Texas, died after they could not access timely reproductive care in states that ban termination of pregnancy. There are almost certainly others. In Houston, Jocelyn Barnica died in September 2021, just days after the state's 6-week ban went into effect. Barnica, 28, was miscarrying at 17 weeks, but doctors did not offer her the medical standard of care to speed up labor or empty her uterus for 40 hours until after the fetal heartbeat had stopped. Her husband said she was told it would be a crime to intervene. This left her seriously exposed to infection, expert told ProPublica. 3 days later, she died from an infection leaving behind a young daughter. Now, Jocelyn was married. These bans harm women that actually want to have babies, who want to expand their families. It doesn't just impact the women that are using abortion as birth control or those women over there. No, it impacts wives. It impacts Christians too. I'm sorry, I said I wasn't going to editorialize. Okay. Her death was preventable, according to more than a dozen medical experts who reviewed a summary of her hospital and autopsy reports at ProPublica's request. They called her case horrific, astounding, and egregious. The doctors involved in Barnica's care at HCA Houston Healthcare Northwest did not respond to multiple requests for comment on her case. In a statement, HCA Healthcare said, "Our responsibility is to be in compliance with applicable state and federal laws and regulations, and that physicians exercise their independent judgment." The company did not respond to detailed questions about its policy, but also, please remember, Ken Paxton said that emergency care doctors can let these women die. He went to the Supreme Court. Supreme Court said that you can let pregnant women die without giving them the care that they need. So that's what they have going on in Texas. Now let's get to Nevaeh Crane. Nevaeh Crane was 18, made 3 trips to the emergency room in rural Southeast Texas last year for vomiting and abdominal pain, waiting 20 hours before doctors admitted her. Doctors insisted on 2 ultrasounds to document fetal demise as Crane's vital signs grew more alarming. By the time they rushed to operate, sepsis has spread throughout her body and her organs failed. Experts who reviewed a summary of Crane's medical records for ProPublica said it may have been possible to save both the teenager and her pregnancy if she had been admitted earlier for close monitoring and continuous treatment. Doctors involved in Crane's care did not respond to several requests for comment. The 2 hospitals, Baptist Hospitals of Southeast Texas and Christus Southeast Texas St. Elizabeth, declined to answer questions about her treatment. And the wild thing about her, she is a pro-life conservative. And she and her mother didn't believe in terminating pregnancies. But the thing is, this is going to impact these people as well. But like I said, they believe it's those women over there that need these bans or need terminations. They don't look at it for themselves, and that is literally to save women's lives. Okay, what is a medical emergency? The cases highlight how termination laws can interfere with maternal health care, even for those who want to have a child. Much of the confusion hinges on the definition of a medical emergency. In many cases, women experiencing a miscarriage or a pregnancy complication may be stable, but requiring them to wait for a termination until signs of sickness are documented or the fetal cardiac activity stops violates the professional standard of care, putting them at higher risk that a life-threatening infection or other complications could develop and be harder to control. Attaching criminal penalties to termination procedures has led to a chilling effect, making some physicians more hesitant to care for patients experiencing pregnancy complications in general, doctors told ProPublica. After ProPublica's reporting, State Senator Brian Hughes, the author of one of the state's bans, wrote an op-ed in the Houston Chronicle. He said that the women were wrongfully denied care, but he blamed media outlets, including ProPublica, for publishing stories that made doctors afraid to treat the women. So it's the media's fault. Okay. When a mother's life or major bodily function are in jeopardy, doctors are not only allowed to act, but they are legally required to act. And contrary to what ProPublica would have us believe, Texas law does not prevent them from aiding their patients and saving their lives. He argued that the medical emergency exception in Texas's new termination bans used the same language as laws from the 1800s. We did not want to risk confusing medical providers by changing the definition, he said. But that language was written at a time when many more women died in pregnancy and childbirth before medical innovations such as suction devices to empty the uterus and lower the risk of sepsis helped make maternal care vastly safer. Hughes is a licensed attorney who lists no medical training on his Senate webpage. ProPublica repeatedly requested an interview with Hughes to further understand his interpretation of how doctors should apply the law in specific scenarios. He did not respond to a detailed list of questions and requests to comment for this article. There is no state office that doctors can call to make sure their decisions in miscarriage cases do not violate the law. Yet Texas Attorney General Ken Paxton has made it clear that he will not hesitate to prosecute doctors if the terminations they provide do not meet his interpretation of a medical emergency. Last year, a Dallas woman asked for approval to end her pregnancy because her fetus was not viable and she faced health risks if she carried it to term. Paxton fought to keep her pregnant, arguing that her doctor hadn't proved her situation was an emergency, and he threatened to prosecute anyone who helped her. The courts sided with him, and the woman traveled out of state for the termination. I'm going to leave that there, and I'm going to do a part two because I do believe that this is worthy of putting it completely on video. So stay tuned for part two. This is going to be part two of ProPublica's article, Texas Lawmakers Push for New Exceptions to State's Strict Termination Ban After the Deaths of Two Women. I already did the first half of the article. It's a really long article, so this is part two. So we ended right here where the Dallas woman had to travel out of state to get a termination. And it just boggles my mind that people like Ken Paxton want women to stay pregnant even though the fetus is not viable. Like, what is the thought process of that? I have no idea. Anyways, let's get back to the article. It says, warnings from the medical community. After reading ProPublica's stories, 111 Texas OBGYNs signed a letter placing blame for the deaths squarely on state termination laws that does not allow us as medical professionals to do our jobs. The law does not allow Texas women to get the life-saving care they need and threatens physicians with life imprisonment and loss of licensure for doing what is often medically necessary for the patient's health and future fertility, they wrote. Their letter adds to years of warnings from the medical community and from patients themselves. 20 women who were denied terminations for miscarriages and high-risk pregnancy complications joined the lawsuit against the state. They asked the courts to clarify the state's exception, but the Texas Supreme Court refused. Dr. Austin Denard, a Dallas OBGYN, is one of the women represented in the lawsuit. She has seen the consequences of the laws from both sides. As a doctor, she has to call a hospital lawyer anytime she wants to provide a termination care to patients facing emergencies. She also was personally affected when she was pregnant and learned her fetus had anencephaly, a condition in which the brain and skull do not fully develop. Texas's law would have forced her to carry to term, putting her through more health risks and making her wait longer to try again for another pregnancy. So she traveled out of state for termination. She said lawmakers have failed for years to listen to the doctors who have to navigate these laws. In a response to Hugh's op-ed, she said, "We're the ones with boots on the ground. We're the ones taking care of these patients, and we're the ones telling you it's very nebulous and confusing, and we're all terrified." State Senator Carol Alvarado, who filed the Senate version of the bill, said she worked with physicians who represent major medical organizations to draft the exceptions. This bill is not about politics. It's about ensuring that doctors can provide life-saving care without hesitation or fear of prosecution. This bill is about restoring trust in our healthcare system and ensuring that no one has to endure the heartbreak of wondering whether more timely medical care could have saved their loved one. Molly Duane, a lawyer for the Center for Reproductive Rights who represents the women who are suing the state, said the bill, if passed, could help save some lives, but cautioned that without removing the threat of criminal penalties, some doctors might still deny care. Exceptions don't work in reality, no matter how clear they are, Duane said. We've seen hospitals turn away Texans facing life-threatening ectopic pregnancies, even though providing a termination in these cases is legal under state law. As long as doctors face the threat of jail time and loss of license, they will be terrified to provide care, where the medical board stands. In his op-ed, Hughes said that the Texas Medical Board has issued guidance that an emergency doesn't need to be imminent to keep physicians from doing what is medically necessary under the law. But Denard, echoing many doctors who spoke to ProPublica, said the board was incredibly unhelpful. The guidance instructed doctors on ways they could document why the termination was necessary and still left open the question of how lawyers and courts might interpret it medically necessary. None of them want to face the reality of the situation, which is that laws that were put in place are directly harming pregnant women, and it is their fault, she said. The board, whose members are appointed by the governor, issued the guidance earlier this year after declining for more than 2 years to respond to questions about how the law should be interpreted. Even as patients facing health risk publicly shared their stories of being denied care, and journalists asked the board to respond. The board issued guidance only after Texas Supreme Court directed it to do so. The president of the board, Dr. Sharif Zafran, said in an interview that it would be inappropriate to weigh in without that direction. Somebody could easily sue the medical board and say, you shouldn't have done this, and then we'd be in limbo also. And that could actually have dragged things out even longer. It's always about law. It's not about women's lives. Why can't it be about women's lives and just doing what's best for the women? And that's what it says at the bottom. In the meanwhile, women's lives were left in the balance. Exactly. Last year, lawmakers created a new exception for two conditions that the original law had not addressed: ectopic pregnancies and pre-viable premature rupture of membranes when a patient's water breaks too early, causing a miscarriage. But the exception is small comfort, some doctors say. Is written in a way that only allows doctors to make affirmative defense for a legal penalty. An affirmative defense, if found credible by a judge or jury, means the defendant wouldn't be liable for alleged acts even if he or she committed them. Nobody wants to be that poster child, said Robert Carpenter, Houston OBGYN, who signed the letter. The Houston Chronicle also published 10 letters to the editor in response to Hughes' editorial, 8 of them arguing against his claim that that Texas termination ban is clear. Among them was Trevor M. Bibler, an assistant professor at Baylor College of Medicine Center for Medical Ethics and Health Policy. If doctors weren't threatened with jail time and accused of murder just for upholding a basic standard of care, then these tragedies wouldn't have happened, he wrote. The possibility that the cause of these tragedies are the doctors who read the writings of left-wing media rather than law is absurd, disingenuous, and not at all convincing. His law, not the media, is the cause. Howard says she's hopeful the Texas legislature will listen to the medical community and the public and create health and other exceptions in the termination laws. She also pointed out that President-elect Donald Trump has said that he supports exceptions in cases of rape and incest, and which Texas ban does not include. She filed a separate bill to propose such exceptions. It's really just unbelievable from a state that considers itself to be pro-life that these obstacles will be put in place that are the antithesis of pro-life, because they're not pro-life. They're forced birth and pro-controlling of women's lives. As other states assess whether to ban or protect reproductive rights, Texas is providing an example of what to expect. In Wisconsin, State Supreme Court Justice Jill Karofsky recently pressed an attorney for the state to explain whether a termination ban on the books from 1849 would stop doctors from providing termination care to patients who were experiencing miscarriages if the court allowed it to go into effect. Describing Barnica's case, she asked for clarification. She suffered an infection that unalived her because medical providers were unwilling or unable to give her the health care that she needed, she said. That's a scenario that could easily, and perhaps has easily, played out here in Wisconsin under your interpretation of the law, couldn't it? I'm not sure, Justice Karofsky, the attorney responded. I'm not a doctor. And that's it. I'm not a doctor. Why is it such that doctors are not able to create the care that women need versus these lawmakers and attorneys? Why does there have to be such legalese in providing care versus just doctors and patients providing the care that the women need? All right, like I said, this was a long article, and I appreciate all of the work that ProPublica is doing. And because of their highlighting these women's stories, I do believe that it is changing some of the minds, because so many of these forced birthers believe it's just loose and lascivious women that are just out here doing all of these X acts and being easy and not using their birth control, when this is in fact harming women that are trying to expand their families and want to have kids. All right, join the conversations. Let me know what you think. Don't forget to like, comment, and share.